All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court and to this year's Florida High School Moot Court competition. We're delighted to have this competition here this year and look forward to hearing the arguments presented by these excellent students, and want to welcome everybody to the competition and congratulate everyone who has participated in getting here thus far. Are the petitioners ready? You may proceed.
May it please the court. Good afternoon, Chief Justice Polston, Your Honors. My name is Jillian Molina, and today I, along with my co-counsel, Julie Silvers, will be representing the petitioner in today's case. At this time, we would like to request to reserve 2 minutes for rebuttal. I will be addressing question 1, which asks the court whether or not the investigatory stop that was conducted violated petitioner's rights under the Fourth Amendment, and my co-counsel will be addressing question 2, which asks the court whether or not the sentence imposed constitutes as cruel and unusual punishment because the sentence was mandatory. On March 30th, 2013, Springdale North High School received an anonymous tip which accused a student, Jesse Davis, of future drug use in an overflow parking lot. The anonymous tip read, "You might want to check out Jesse Davis's vehicle. Saw some drugs under the back of the passenger seat when I was in there recently. Heard Jesse Davis will be using after school today in the overflow parking lot." When evaluating this case, we ask that you apply the de novo standard of review that is established in KW v. State.
I want to ask about the fact. Is there the fact that it says that he'll be using, is the record clear? Does that mean that he would be using drugs as opposed to selling drugs? Was that developed, or is there a common understanding that he'll be using meant that he'll be doing drugs?
Yes, Your Honor. The anonymous tip just specifically say that he will be using after school. However, that's not what we're questioning today. We're more of questioning the anonymous tip as a total, as a whole.
Well, as you do that and you use the same law, this is a school setting, partially. We have the school where the report is made, and we have a parking lot, as I understand it, that's not school property. So do we apply the law with regard to Fourth Amendment in a school setting, or as though this is a public street? Because JL tells us that the law may be different for airports and schools than it is for a jail setting, which is a case that would be favorable to you. So which law do we apply and why?
Your Honor, we argue and we strongly agree that we should use Jesse Davis's Fourth Amendment rights as it applies to the Constitution for the fact that the overflow parking lot was not on school property. School regulations and any sort of rules that they may implement on their students would not apply to the overflow parking lot for the fact that it was not in the jurisdiction of the school.
Well, I thought they used this every day. This is where they park, isn't it?
Yes, Your Honor. Students do use this overflow parking lot when there is not any parking available at the school. However, it's a private property that the owner gives consent to the student specifically to use.
Let me go back then to the question that Justice Perriente asked you about using, because it seems to me that it becomes an important issue in your analysis of whether or not the stop was justified, because we look at whether or not the officer actually verified items that are in the tip, correct?
Yes, Your Honor.
And so if using means that he was physically taking the drugs himself, the officer, certainly it seems to me under these facts, did not observe that as a factor. But if using means something more generic, it may make a difference in our analysis of whether or not the officer verified the items that were in the tip. So I don't think you actually answered her question about what does the term using mean in this context?
Well, Your Honor, since the drugs that were involved in this case are the pills of oxycodone, we would agree that it would be using as in taking these pills.
And consuming.
Yes, Your Honor. And in Florida v. JL, a three-pronged test was established for when anonymous tips were sufficient enough to for a reasonable suspicion to be obtained. And the first prong of this test states that an anonymous tip provides a description of a particular person at a particular location illegally in the possession of drugs. The second prong of this test states that police promptly verify the pertinent details of the tip except for the existence of the drugs. And the third prong states that there are no factors that cast doubt on the reliability of this anonymous tip. Now, the anonymous tip only has to fail one of these prongs in order for reasonable suspicion to not have been obtained. We strongly argue that it does not pass the third prong of this test that states that there are no factors that cast doubt on the reliability of the tip. For the fact that Officer Carpenter did receive this tip through a third party. It was received by Springdale North High School, which was then given to Officer Carpenter. And the fact that it was a talk-to-text communication technology that the school had, and during the transcribing, the anonymous tip could have been distorted.
When you look at what was actually said in the tip and then what the school said, isn't the school saying that did it sound like a certain student's voice? What did they say that pointed to a particular student having given this tip?
No, the anonymous tip, they did not say, Your Honor, that it sounded like a particular student. Rather, they believed that it could have possibly been a student that carpooled with Jesse Davis named Cam Ryder. However, that still is not definitive in the anonymous tip itself, since it does use very vague language. Even though it does say terms such as when I was in there, there's no way for you to narrow down specifically as to who it was that was inside of that vehicle, especially since the rest of the terminology in the anonymous tip includes such as might, recently, after school, as well as heard. Now, might establishes that there may be a possibility. Recently could be any time period from yesterday all the way to months ago. There's really no amount of time that can be determined by the use of that word recently.
What's the significance of the fact that the officer learned the person who probably made this report, which may make it less anonymous, was also running for valedictorian and shared the co-captain role? Would that, and then they never then interviewed the person they thought had made it. Is that helpful to your side, or does that work to the advantage of the state?
No, Your Honor. I don't think we argue that it does not matter at all for the fact that the person that did submit this anonymous tip is still anonymous. There was no way to actually determine who it was that sent the anonymous tip.
All right. Now but don't you think, that the fact that somebody could just make a statement and maybe they have a motive which is not a good motive, which is I'd like to get this. Maybe he planted, maybe the guy that made the tip, maybe he planted the drugs.
Yes, Your Honor.
Shouldn't that have been concern to the officer as to whether this was even reliable at all?
Yes, Your Honor, we do agree with that point. The fact that Officer Carpenter did not even question Cam Ryder until after the arrest, and also that they were competing, the fact that it could have been Cam Ryder just sending an anonymous tip that had no truth in it could mean that that there could have been any other student in that school that could have done the same thing, which reduces the reliability extremely.
Well, why wouldn't the predictable behavior exception that's discussed in JL have some application here? Because as in JL, they make that point that the law would be different had there been predictable behavior. And here, they waited, they followed exactly what they were told was going to happen, and it did happen, down to the parking lot. Your client gets into the truck and sits in the truck and then makes motions into the back seat. So why is not the predictable behavior exception apply here?
Your Honor, I see that my time has expired. May I briefly answer the question? Your Honor, Officer Carpenter did observe Jesse Davis when he was waiting for him after the overflow parking lot. However, we strongly argue, Your Honor, that Officer Carpenter did not observe anything that would insinuate or even show that he was involved in any possible criminal activity. He did look around, and he was there in the overflow parking lot 10 minutes after everyone else left. However, those actions do not show that he was being involved in any sort of criminal activity, nor when Officer Carpenter approached the vehicle and started questioning him, he did not see or smell anything that would suggest he was doing anything that's criminal activity. Your Honor, so once again, we ask that you overturn the lower court's decision and rule that Jesse Davis's Fourth Amendment rights were violated. Thank you.
Thank you.
May it please the court? Good afternoon, Chief Justice Polston, Your Honors, and opposing counsel. My name is Julie Silvers, and today I'll be addressing question 2 on behalf of the petitioner. Question 2 asks the court whether the sentence imposed upon petitioner Jesse Davis under Florida State Statute 893.135 constitutes as cruel and unusual punishment under the Eighth Amendment because the imposition of the sentence was mandatory. Now, though Mr. Davis was 17 at the time of his arrest, he was charged as an adult and later sentenced to 25 years imprisonment and a $500,000 fine, which was the minimum possible sentence that could be imposed upon him for possessing over 28 grams of oxycodone. We strongly urge this court to overturn the lower court's decision and find that the imposition of this sentence unconstitutional. Now, the Supreme Court has continually expanded their precedent regarding the Eighth Amendment as it applies to juveniles, essentially beginning in 2002 in Atkins v. Virginia, in which the Supreme Court banned the imposition of capital punishment on the mentally retarded, stating that they have a lessened culpability, which makes them undeserving of the most severe punishments. And then in Roper v. Simmons, the Supreme Court compared this lessened culpability of mentally retarded to the lessened culpability of juveniles, and then they banned the imposition of capital punishment on all juveniles. The Supreme Court then further expanded the Eighth Amendment scope as it applies to juveniles in Graham v. Florida, in which the Supreme Court banned the imposition of life without parole for juveniles who had committed non-homicide offenses, once again citing their lessened culpability, as well as stating that they have various mitigating characteristics that judges must be able to consider when choosing an appropriate punishment. And finally, in Miller v. Alabama, the Supreme Court banned the imposition of mandatory life without parole on juveniles for the reasons of their mitigating characteristics and calling for an individualized sentencing scheme. So
your argument here really is that because it's a mandatory sentence, that makes it cruel and unusual.
Yes, sir.
So does that mean if the trial court had imposed, he got a 25-year sentence, correct?
Yes, Your Honor.
If he had just imposed a 25-year sentence, that this would be a constitutional sentence?
Are you stating that?
I'm saying if it was just a 25-year sentence and it wasn't mandatory, simply a 25-year sentence, that would be okay.
Yes, Your Honor. It was established in Pay v. State that the 25-year and $500,000 fine is a proportional punishment for this crime.
But the 25-year, if the trial judge imposes the 25 years and doesn't say anything about the unique characteristics of a juvenile, which is what is talked about in Graham and in the Miller case, Why isn't that just as bad as the mandatory 25 years, since you're not taking into consideration, really, that this is a juvenile?
Yes, Your Honor, we are not arguing that the proportionality of the crime to the punishment in this case is what makes it unconstitutional, but for the fact that the judge was not able to consider the mitigating and distinguishing characteristics of the juvenile under the categorical approach, which makes it unconstitutional.
Which aspects of the prior precedent do you believe address the mandatory aspect of this case? Because what if the Florida legislature had a 1-year minimum a mandatory minimum sentence? Is that unconstitutional because it's a mandatory 1 year?
Yes, Your Honor, we would still argue that all mandatory sentences as applied to juveniles are unconstitutional. And we can compare the case of Miller v. Alabama to the present case, for in essence, those juveniles were given a mandatory minimum. The law required that they either be punished with capital punishment or life without parole for committing homicide. And because of the precedent established in Roper v. Simmons, a judge could not impose capital punishment on these juveniles. So the judge had no other option but to impose life without parole on these juveniles. And the court established that this was unconstitutional, and they then advocated for an individualized sentencing scheme in which judges could go on a case-by-case basis and consider the mitigating characteristics of juveniles and their lessened culpability.
But isn't also a part of that the reason that these kind of sentences were found to be unconstitutional is because they don't take into consideration the fact that the juvenile might be rehabilitated, and it's the equivalent of taking away the juvenile's life. And I just don't see the same analysis when you're talking about a 25-year sentence.
Yes, Your Honor. The majority of the precedent does deal with the most severe end of spectrums of punishment, capital punishment in Roper and life without parole in Miller and Graham. However, their internal reasoning regarding the distinguishing and mitigating characteristics of youth are not crime-specific. Regardless of a juvenile committing homicide, possessing drugs, or robbery, they still contain this lack of maturity, underdeveloped sense of responsibility, and they're
so even if it's, as Justice Lewis asked you, even if it's a mandatory 1-year sentence, and they're given that mandatory 1-year sentence for an armed robbery, it would be an unconstitutional sentence.
Yes, Your Honor, we would still argue that judges must be able to consider in juvenile cases the mitigating characteristics of youth and all of the totality circumstances of the case when determining an appropriate punishment.
Where in Graham or Miller does it say that?
I'm sorry, Your Honor.
Where in the U.S. constitutional decisions does it say that?
Well, Your Honor, Graham and Roper both established distinguishing and mitigating characteristics of juveniles, including their lack of maturity. Graham stated that age itself is a mitigating factor and that an offender's age is directly relevant to the 8th Amendment, and criminal procedure laws that fail to take a defendant's youthfulness into account at all would be flawed. And then later in Miller, when they advocated for an individualized sentencing scheme, they advocated that judges should be able to consider these mitigating characteristics when choosing an appropriate punishment.
But if the legislature said these crimes, an adult would get 10 years for it, mandatory 10 years, but a juvenile would get a mandatory 1-year sentence, would that be okay?
Well, Your Honor, the courts have established that juveniles and adults are distinct for sentencing purposes. And when juveniles are tried in adult courts, they are susceptible to the same sanctions that are imposed upon adults. However, they are not subject to all of the sanctions that are imposed in adult courts. For example, even when juveniles are tried in adult court, they still cannot be given capital punishment. They still cannot be given mandatory life without parole. And we are arguing that to make it unacceptable to impose mandatory minimums on juveniles.
But don't you think in crafting this, you're asking this court to go very far? And it seems that you may be trying to make an argument that has to be rejected because it goes so far. Because in a case, if the juvenile's 14 years old and gets a 1-year sentence, unless they'll be 15, they'll have a full life ahead of them, able to be rehabilitated. I had really thought Miller and Graham dealt with the idea that they would have no way to ever be rehabilitated, because for them, these sentences, which were a sentence exceeding their life expectancy, was equivalent to the death sentence. So are you sure that that argument that no matter what the length, it has to be individualized sentence, shouldn't we consider other factors like this is a nonviolent crime, that it almost stretches the limits to think that 25 years for possessing some pills would subject anybody, but certainly not a 17-year-old to 25 years. So you're asking us to impose just a blanket holding that no mandatory sentence for a juvenile could be constitutional?
For a juvenile, yes, Your Honor. And ultimately, the judge does make the sentencing determination. That was established in Graham. And it might not become problematic when dealing with very small mandatory minimums. In those cases, a judge may wish to impose that sentence or more on the juvenile, and it would not necessarily become problematic. Once again, we would ask this court to overturn the district court's decision and find that Mr. Davis's Fourth and Eighth Amendment rights were violated. Thank you.
Chief Justice, and may it please the court. My name is Brandon Becker. I'm here today along with my co-counsel Matthew Saray, and we are representing the respondent. There are two issues posed to the court today.
Could you speak up, please, in your mic?
The first of which is whether or not the investigatory stop is in violation of the Fourth Amendment. The second of which is whether or not the sentence handed down to the petitioner is in violation of the Eighth Amendment. I will be speaking in regards to the Fourth Amendment. This court should uphold the ruling of the 6th District Court of Appeal and find that there was reasonable suspicion under the totality of the circumstances for the following three reasons. First, the tip was specific, detailed, and predicted future activity. Second, the tipster is readily discoverable. And third, there was police cooperation and additional surveillance.
Well, it seems to me that, what the police corroborated was probably the kind of activity that would take place every day. He left the school, went to the parking lot, and got in his truck, and that seems to me like some very ordinary activity. So what beyond that? He dropped something on the floor, which later turned out to be, I believe, his cell phone. But so what beyond that was so specific that it would give a police officer reasonable suspicion?
Your Honor, under the totality of the circumstances, Officer Carpenter had reasonable suspicion to justify a stop because of his cooperation. When going into the overflow lot, which the record reflects is where the drugs were supposedly being in the petitioner's car, he saw the petitioner exhibit nervous behavior and demeanor.
Could we just start with the first part? Every day, students, and I don't know how many students in this high school?
The record doesn't specify.
All right, so they drive to, if they're older, they drive to school, and they go get their car. So the idea that he would be going and getting his car in an overflow lot is that's like what they do every day. So what is that means that would make this reliable?
Your Honor, it's the specificity of the tip itself. The tip itself, as the record reflects, gives the who, the what, the where, and the when. It tells us that the petitioner is going to be in the overflow lot with drugs behind the passenger seat after school. It gives a specific time frame, and it gives firsthand knowledge of where the drugs are going to be. The record says—
How is that any different than JL, where they said there's going to be a guy with a plaid shirt, he's going to have a gun, and he's going to be at the bus station?
Your Honor, in the 2000 U.S. Supreme Court case of Florida versus JL, they ruled that the bare-bone tips are not enough to justify a stop. However, in the case presented, we don't have a bare-bone tip. We have a tip that's more than a mere description, which is what the court of JL ruled is not enough to justify a stop.
If we were to uphold this, what would prevent any student who had, this is an anonymous tip line, from deciding they had a grudge against another student and planting, either planting the drugs or whatever, and just then calling in this tip And if the police weren't required to further investigate the reliability of the tipster, wouldn't we sort of eviscerate the student's constitutional rights?
Your Honor, the students' constitutional rights are not violated by the stop, because Officer Carpenter, in the case presented, corroborated the tip on the specificity of the tip. And the second reason why this court should affirm is because the tipster was held to a higher degree of reliability and veracity, because they're readily discoverable.
Well, now, when you say that, and reading the materials that have been presented to the court, I thought this was just a call-in, and then it transcribed it out into some type of email message. But I didn't see in the record that it said they could trace these down. Is that in the record?
No, Your Honor, that is not in the record. However, the tip comes from an anonymous tip line, but the student body, the administration of the school knows two things about who the tipster is. They can narrow it down to a population of students who go to their school and who have been in the petitioner's car. Being able to narrow down the tip to that amount of...
Wait. I mean, that's assuming that factually the person was in the car. I mean, I can see in the predictability that you may draw that conclusion, but there's nothing that we have, do we, that says that we know who's been in this person's car and we have a record of it?
No, Your Honor. We don't know for sure that the tipster has been in the petitioner's car. However, as the record reflects on page 21, the tipster says that he has firsthand knowledge of seeing drugs behind the passenger seat in the petitioner's car. Under the totality of the circumstances...
But that's him. You see, that's where I'm having trouble with this, because if they knew that who was the likely person, but Officer Carpenter, what we ought to encourage the officer to do is to talk to the tipster, because there was a real concern that the defendant was going to be valedictorian, and the tipster was in the running to be valedictorian, precisely the kind of person that might have had a motive to frame the defendant.
Yes, Your Honor. However, if the officer was to conduct an interview, it would cause a chilling effect to the anonymous tip line in and of itself. Conducting an interview would take away from the anonymous factor, which would lead less kids to give these tips to the school to try to counteract the rampant drug use at the school.
I mean, and that is a problem, because what you sacrifice, if you want to make sure that you're trying to find out whether students are bringing guns to school and all of that, is that may be valid, but you may sacrifice being able to use the fruits of that search in a criminal prosecution. In other words, if say the school has an interest in guns not being brought into school, and there are people that are going to give tips on it, maybe they ought to be able to go see and go search. But the question is whether it's going to be proper under the Fourth Amendment. What's that? Isn't that what we want to be concerned about? The freedom of students to sort of feel like they can tell what's going on, but also not allowing them just to even feel like they can give those tips without any repercussion.
Yes, Your Honor. The Fourth Amendment does give light to justifiable stops under the Supreme Court case in 1968 of Terry versus Ohio, in which they ruled that if there is articulable facts connected to a specific suspect, a brief on-the-spot detention is justified, or an investigatory stop. You mentioned earlier, Your Honor, that there might have been motive to who gave the tip. However, there may be speculation who gave the tip, but that only gives the tipster a stronger motive to tell the truth, being that he could be readily discoverable and found out. The severe consequences of lying to the police gives the tipster a motive to tell the truth and not to lie, because of the severe consequences that can come their way. As to the third,
I thought there was no way to really find out who the person was, so I don't see how that would give anyone any motive to tell the truth if you can never be found, if you can't determine who actually made the call.
Your Honor, the administration of North Springdale High School can narrow down the tipster to two specific pools. It's first.
They can narrow it down how?
They can narrow it down to someone who goes to North Springdale High School and someone who's been in the petitioner's car.
But how can they do that? They can only do that because he said he was. They can't do that objectively.
No, Your Honor, it cannot be a completely objective investigation. However, we can narrow it down to a specific student body population, being that the tip is true. However, even if the tip is deemed not to be enough because it is not true, there is still police cooperation and additional surveillance which can give light to reasonable suspicion under the totality of the circumstances. In the 1990 U.S. Supreme Court case of Alabama versus White, the court ruled that in order to have reasonable suspicion is held to a lower standard than that of probable cause. Probable cause, in order to justify probable cause, you need a fair probability of something to happen. However, reasonable suspicion, in order to be justified, needs to have more than just a mere hunch. Officer Carpenter, in this case presented, acted off of more than a mere hunch. He acted off the who, the what, the where, and the when of the tip. Drawing a parallel to White and the case presented, we see that the stop was justified. In the case of White, the officer had the specific details of where the suspect was supposedly going, that they were supposedly having drugs with her on her person in a carrying case, and that they were going to a specific place. However, in the case presented, we have the same idea. We have Officer Carpenter going into the overflow lot. We have him observe suspicious demeanor and behavior by the suspect, or in this case, the petitioner, and we have him corroborate the facts of the tip. We have Officer Carpenter view and testify in the lower courts that he saw the petitioner reach behind the back of the passenger seat where the drugs are supposedly being. Under the totality of the circumstances, Officer Carpenter had enough reasonable suspicion to justify a stop. It is for the aforementioned reasons that the respondent respectfully asks this court to uphold the ruling of the 6th District Court of Appeals. Thank you.
Thank you.
Mr. Chief Justice, and may it please the court, my name is Matthew Saray, and I'll be representing the respondent, the state of Florida, in today's case. As my co-counsel mentioned, I will be addressing the Eighth Amendment issue, specifically whether or not the petitioner's sentence constituted as cruel or unusual punishment. Your Honors, the decision held in the 6th District Court of Appeals should be upheld for the following two reasons. First, since the petitioner's sentence was a term-of-year sentence, this court should conduct a gross disproportionality analysis, which takes into account the gravity of the offense with the severity of the punishment, rather than adopt a categorical approach in which the court exempts certain punishments from entire categories of individuals, such as juveniles or the mentally impaired. And second, even if this court does adopt a categorical approach, the mandatory nature of this term-of-year sentence is not enough to constitute a cruel and unusual punishment. Before going into the gross disproportionality analysis, it's first important to note that in the Supreme Court case in 2010 of Graham versus Florida, the Supreme Court outlined two different ways in which something can be deemed cruel and unusual. The first of which is for term-of-year sentences. Graham versus Florida cites Tasalem versus Helm in 1983, in which the Supreme Court stated that for term-of-year sentences, if the sentence is grossly disproportionate, then it is cruel and unusual.
As I understand your opposition's argument on this morning, it is the lack of individualized sentencing, and that's really what that argument flows on, and that all of the cases, according to your opponent, requires that element due to the aspect of the individual being a juvenile. Why is that wrong? Because all those cases talk about that you need individualized sentencing, recognizing the frailties of youth.
Your Honor, when we're using a gross disproportionality analysis, the court does not necessarily take into account the categorical factors such as being a juvenile. For example, the cases that my opponent bring up actually fall under the second category that Graham outlines, the categorical approach, in which the court does take into account these specific factors. Graham outlines that the categorical approach has largely been reserved for cases that involve the death penalty, or, as Graham furthers, cases involving life without parole. Miller versus Alabama in 2012 and Graham both liken life without parole to the death penalty.
But they also went to, for non-homicide offenses, very lengthy prison sentences, correct?
While it is true, Your Honor, what Miller explains is that life without parole and the death penalty share characteristics that no other sentences actually share.
I thought there was one, didn't they go one step farther in one of those cases to say a term of years that would exceed the life expectancy for a non-homicide offense?
Your Honor, in Wall versus State, the 2nd District Court of Appeals actually first admitted that the Supreme Court has never used a categorical approach to life without parole or the death penalty. And although Wall versus State did use a categorical approach for a term of year sentence, Wall was unique in that it was consecutive sentences totaling 92 years, which was consequently the rest of the juveniles.
I think what they're arguing, and there is some merit to this. First of all, we're dealing in this case with a non-violent offense. there might be even adults. How many pills were involved?
Your Honor, the record does not specify how many.
But there were pills of Oxycontin,
yes.
Nothing we would encourage. But now this almost valedictorian ends up essentially losing the rest of his youth and the rest of his developing years in prison with nobody able to rehabilitate him or look at the factors of age. Why in that circumstance, where even for an adult this is such a lengthy sentence, why shouldn't the court adopt a Miller-Graham analysis that requires the sentencing judge to consider the individualized factors such as his age, youthful indiscretion, and then other factors that might go into deciding whether 25 years or more is a proportionate sentence?
Your Honor, when we're dealing with the first whether or not using the categorical approach or not, Miller does explain that the reason why the categorical approach was used for a juvenile on life without parole was because of their greater opportunity to rehabilitate. Since the court today is dealing with 25 years or a term of year sentence, the juvenile still has an opportunity to rehabilitate and re-enter society. Even further, since the juvenile has been charged with drugs, it could be potentially more dangerous for the juvenile to not go through the justice system and rehabilitate.
Wait. What was that last comment?
Potentially, it would be more dangerous for the juvenile if they don't get the chance to rehabilitate through the justice system.
We're really saying instead a 25-year sentence for a almost valedictorian, it will teach that defendant a lesson versus if the person has drug issues, getting him some meaningful rehabilitation outside of the prison setting. Do you have any data that's in the record to support that kind of statement, that this is really better for this defendant than if we let him either go in the juvenile system or be rehabilitated outside of prison?
Your Honor, there's nothing in the record that specifically states that it would be better for the juvenile, but when we're dealing with this particular sentence, it's actually important to look to Harmelin versus Michigan, the Supreme Court case of 1991, in which they gave some of the several guiding principles of doing a disproportionality analysis. In fact, Harmelin versus Michigan states as the first guiding principle of disproportionality that sentences should be up to the legislative prerogative. Essentially, as the case of State versus Benitez in 1981 explains, where this court explains, the legislature of Florida has determined that deterrence is particularly important when having sentences or when determining sentences.
But didn't the U.S. Supreme Court in Miller talk about the child being immature, a person being immature until they're maybe 22, and then if they're in prison, and this guy was a valedictorian of the class, which meant he was pretty intelligent. He probably had a chance for a future. Under your analysis, he would be able to get his PhD in criminology in prison, come out a worse person that's supposed to be rehabilitated. Where is the opportunity for him to be rehabilitated at an earlier age?
Your Honor, although there is no possibility, since it is a mandatory sentence, the juvenile still does have the capacity to rehabilitate given that it is a term of year sentence. Miller explicitly talks about how life without parole is much different from other sentences because you don't get any opportunity whatsoever to rehabilitate.
Under the case law that talks about gross disproportionality, is there no ability to look at that a juvenile, a grossly disproportionate sentence for a juvenile might be different than one for an adult? Has any U.S. Supreme Court case made that distinction?
Your Honor, Miller does admit that when there is some discretion when determining whether or not the juvenile is chosen to be tried as a juvenile or tried as an adult. And the Florida legislature has determined it incredibly important to deter drug use. So although 25 years may seem like a very harsh punishment, the Florida legislature has determined, since oxycodone is such a potential threat to society, that it is the appropriate punishment to prevent other people from using it.
But the Florida legislature didn't, it's the prosecutor that decides whether to charge the juvenile as a juvenile or an adult. The state here could have made a decision to charge this defendant as a juvenile. So we're talking about there's discretion on the prosecutor, but what they're talking about is the lack of discretion of the sentencing judge to take anything into consideration considering this is a juvenile. And why isn't that an Eighth Amendment problem?
Your Honor, that's actually what Harmelin goes on to explain. Essentially, when talking about the legislature, it should be up to the legislature to determine, for example, for a juvenile, if there should be a separate punishment. But
Does Harmelin address juveniles?
No, Your Honor. But
and doesn't it seem like the U.S. Supreme Court is going in a direction, starting with Roper and on, that they are really looking and saying that juveniles, the same, that they're immature, that their brain hasn't developed, and that these are considerations that make them very different than an adult?
Your Honor, that's very true. And in fact, the dissent of Miller explains that, for example, if this trend were to continue as Miller outlines, then it could potentially be 1-year sentences being not allowed, or 6-month sentences. And the problem is there needs to be some sort of bright line. That's why it should be left up to the legislature, so that each state should be allowed to create their own bright lines or be able to determine what sort of punishments should be associated with.
You would agree that there is some line that the legislature itself could cross, right? What if it were 75 years? Would that be unconstitutional?
Your Honor, it could be unconstitutional if it's some larger portion. For example, when we're determining what type of approach to use, 75 years could be equated to life, and other circumstances should be taken into account. But since today's case is involving a 25-year sentence, then we shouldn't necessarily take into account the extreme length of the term of year sentence.
So how should we determine where that line is?
Well, on face value, when we're talking about the proportionality, we can look to Pye versus State in 2006, where the Second District Court of Appeal actually outlined that this 25-year sentence is constitutional and proportioned to the very same mandatory 25-year sentence. And then even further, if we're going to look to Harmelin, Harmelin explains the scourge of drugs and the problem of drugs on society, and actually upheld a life sentence.
So,
Your Honor,
you'd say 75 might be. What about 50? Because I don't think you actually answered the question of where you draw the line. 25's okay. Is 35 okay? Is 45? Where do you draw the line? Because you really should be looking at the same factors, which is the youth and the greater capacity for change and all those things that they talk about in Miller. So
Your
where
Honor,
do you draw the line?
I see my time has expired. Do you mind if I briefly answer the question, then conclude?
Okay.
Okay. So the line drawing, as Harmelin basically states, should be left up to the legislation, since the legislature is the democratically elected people and know each state and each region as best as they can. And so for the aforementioned reasons, I urge this court uphold the 6th District Court of Appeals decision. Thank you.
Thank you. Rebuttal.
Your Honors, we would first like to address the respondent's point that Officer Carpenter, his corroboration and further investigation of the specificity of the tip led to reasonable suspicion. They argued that the tip provided a what, when, how, or who and what. However, within the tip, these aspects are not specific at all. They do state that there are drugs, but they don't state what type of drugs, how much drug, or even if these drugs are illegal. They state that he'll be in the overflow parking lot, but it doesn't say where his car will be located or even what type of car he'll be in. They say after school, but that could range from minutes after school to hours after school. There is no specificity in this tip that would lead it to be more reliable. And though the officer did corroborate these very few and scant details that were provided in the tip, that does not insinuate that suspicious activity was afoot. It is not unusual for a student to be sitting in the parking lot after school for 10 minutes, and the only thing he observed was subjective suspicious behavior. We would also like to address the respondent's point to apply the grossly disproportionality analysis. However, that is not the challenge that we are making today. We are arguing that the mandatory nature requires a categorical approach in response to considering the circumstances of a case and the mitigating characteristics of youth. We understand that the proportionality is not at issue today. And with cases that they brought up, like Harmelin, Pei, these are adult cases, which make them distinctly different from the cases today. When those cases upheld the constitutionality of these sentences, it was distinctly different because it dealt with adults, and the necessity to consider the mitigating characteristics of youth were not present. We'd once again like to ask this court to overturn the district court's decision and find that Mr. Davis's Fourth and Eighth Amendment rights were violated. Thank you.
Thank you for your arguments. Let's everybody give him a hand.